20 words per minute. Get ready. Start. The present reference to the Constitution bench has its own complexity as the centripodal issue in its invitation of the interpretation of Article 239 AA of the Constitution invokes a host of concepts, namely, constitutional objectivity, navigating through the core structure with the sense and sensibility of having a real test of constitutional structure, the culture of purposive interpretation because the court is concerned sustenance of glory of constitutional democracy in a democratic republic as envisioned in the constitution, and understanding the idea of citizenry participation viewed by the lens of progressive perception inherent in the words of a great living document emphasizing on the democratic theme to achieve the requisite practical goal in the world of reality. We may call it as pragmatic interpretation of a constitutional provision, especially the one that has the effect potentiality to metamorphose a workable provision into an unnecessary and unwarranted piece of ambiguity. In such a situation, the necessity is to scan the anatomy of the provision and lift it to the pedestal of constitutional ethos with the aid of judicial creativity that breathes essentiality of life into the same stop. It is the hermeneutics of law that works. It is the requisite constitutional stimulus to sustain the fundamental conception of participative democracy so that the real pulse is felt and further the constitutional promise to the citizens is fulfilled. It gets rid of the unpleasant twitches and convulsions. To put it differently, the assurance by the insertion of article 239 AA by the constitution within bracket 69th amendment bracket close act, 1991 by exercise of the constituent power is not to be renounced with any kind of rigid understanding of the provision. It is because the exercise of constituent power is meant to confer democratic, societal and political powers on the citizens who reside within the national capital territory of Delhi that has been granted a special status. Para. The principal question is whether the inhabitants or voters of an city of Delhi remain where they were prior to the special status conferred on the union territory or the amended constitutional provision that has transformed Delhi instills inverted comma prana inverted comma close into the cells. Let it to be made clear that any ingenious effort to scuttle the hope and aspiration that has ignited the idea of inverted comma march ahead inverted comma close among the inhabitants by any kind of linguistic gymnastics will not commend Tyson. The appellant claims that the status of the voters of NCT Delhi after the 69th amendment has moved from national to real, but the claim has been negatived by the Delhi High Court. Learned Counsel for the appellant criticized the judgment and order of the High Court by contending, apart from other aspects, that the language employed in the entire chapter containing Article 239 AA, unless oppositely interpreted, shall denude the appellant, the National Capital Territory of Delhi, of its status. Para. The criticism is founded on the base that the Constitution of India, an organic and continuing document, has concretized their desire and enabled the people to have the right to participate as a collective in the decision making process that shall govern them and also pave the path of their welfare. Stop the participation of the collective is the vital force for larger public interest and higher constitutional values spelled out in the constitution, and the silences therein and the same are to be protected. Stop. It is the assertion that the collective in a democracy speak through their elected representatives seeking a mitigation of the grievances. Stop para. This court, being the final arbiter of the constitution, in such a situation, has to enter into the process of interpretation with the new tools such as constitutional programmatism, having due regard for sanctity of objectivity, realization of the purpose in the truest sense by constantly reminding one and all about the sacrosanctity of democratic structure as envisaged by our constitution, elevation of the precepts of constitutional trust and morality, and the solemn idea of decentralization of power, and we must say, the ideas knock at the door to be invited. Stop. The compulsive invitation is the warrant to sustain the values of democracy in the prescribed framework of law. Stop. The aim is to see that in the ultimate eventuate, the rule of law prevails and the interpretative process allows the said idea its deserved space, for when the rule of law is conferred its due status in the sphere of democracy, it assumes significant credibility. Stop.